This is an AZ Court Help Legal Talk on when to file in Navajo Family Court.
This presentation is brought to you by DNA People's Legal Services and will provide information about initiating family court actions in the Navajo Nation, such as an action for divorce to establish paternity, child custody, child support, or validation of marriage. This presentation is general in nature and is intended for educational and informational purposes only. This is not legal advice. You should consult with an attorney for legal advice relating to your particular facts and circumstances. The Navajo Nation is organized into 110 chapters and 11 judicial districts. On this map, the list of districts starts with Alamo to Hajile as District 1, but the numbering may differ on other maps online. Each judicial district has defined boundaries that include multiple chapters. For example, the Dilkon Judicial District covers 9 chapters: Bird Springs, Dilkon, Greasewood Springs, Indian Wells, Jedito, Loop, Tiesto, Tolani Lake, and Whitecone. Each judicial district has a district court, a family court, and offers peacemaker services. For this presentation, we are focused on family court. Chapter 7 of the Navajo Nation Code defines the subject matter jurisdiction of the family courts in the Navajo Nation. This includes divorce, paternity, child custody, and child support. The venue for your case, which is the particular judicial district where you file your petition, will generally be the judicial district where you reside, based on your chapter, or for cases involving children, where the child resides. Go to the Navajo Nation Judicial Branch website to find your judicial district. The link is provided here. If you forget the website name, you can use a search engine and enter Navajo Courts. The court clerk at each judicial district will be able to provide you with information and forms for particular types of cases. For example, if you want to file for divorce or child custody or to validate a marriage. In some cases, the clerk may refer you to a legal aid organization, such as DNA People's Legal Services, for legal advice and assistance filling out forms. Note that there are financial eligibility requirements for receiving free legal aid, so you should go ahead and apply for services, but just know that if your household income is too high, you may not qualify. Let's talk about some common legal terms you should know. First, a legal action is begun by filing a complaint with the court. A complaint may be labeled as a complaint or as a petition. Family court cases typically begin with a petition. The petitioner is the party that initiates the legal action by filing the petition. The respondent is the party that responds to the petition. For example, the respondent may be your spouse or the other parent. Next, community property. The community here refers to the marital community. Community property means all property acquired by either husband or wife during the marriage, which is therefore considered to be the property of both spouses. It does not include property which is acquired by gift or by inheritance. It also excludes the earnings of a wife and her minor children while she is living separate and apart from her husband. Separate property is all property, including both real estate and personal property of one spouse, which was owned by him or her before marriage, or which was acquired afterward by gift or through inheritance. Any increase in the value of such property or rents and profits from such property is also that person's separate property. The earnings of the wife and the minor children in her custody while she lives separate and apart from her husband are the separate property of the wife, pursuant to Section 202 of Title IX of the Navajo Code. Next, community property. The community here refers to the marital community. Community property means all property acquired by either husband or wife during the marriage, which is therefore considered to be the property of both spouses. It does not include property which is acquired by gift or by inheritance to one of the spouses. It also excludes the earnings of a wife and her minor children while she is living separate and apart from her husband, pursuant to Section 205 of Title IX of the Navajo Code. Separate property is all property, including both real estate and personal property of one spouse, which was owned by him or her before the marriage, or which was acquired afterward by gift or through inheritance. Any increase in the value of such property or rents and profits from such property is also that person's separate property. The earnings of the wife and the minor children in her custody while she lives separate and apart from her husband are the separate property of the wife, pursuant to Section 202 of Title IX of the Navajo Code. Community debt means, generally, debt contracted during the marriage, which is considered the common debt of the marital community. Separate debt means, generally, debts contracted by one of the spouses prior to the marriage. The other spouse's separate property is not liable for the separate debts of the first spouse, pursuant to Section 203 of Title IX of the Navajo Code. Note, there are provisions under the Navajo Nation Code that treat the husband and wife differently with respect to community debt. First, the community property of the husband and wife is liable for debts contracted by the husband during the marriage. The wife does not have the legal capacity to make contracts binding community property. However, there is an exception. The wife may contract debts for necessaries for herself and her children upon the credit of her husband. In an action by a creditor to collect debt for necessaries for the wife and her children, the debt must first be collected from the community property, then from the separate property of the husband, and lastly from the separate property of the wife. Jurisdictional requirements. For a divorce action, there are residency requirements. A person wishing to file for divorce in a Navajo Nation court must have resided within Navajo Nation territory for at least 90 days. This is a little different from Arizona. Arizona also has a 90-day residency requirement, which is satisfied if either spouse has resided in the state for the required time period. The Navajo requirement applies specifically to the person filing the petition. The question of jurisdiction for child custody actions is a bit more complicated because there are tribal, state, and federal laws that apply. Under Navajo law, the Navajo court may exercise jurisdiction over a Navajo child wherever they reside, based simply on the child's tribal membership or eligibility for membership. Under federal law, the location of the Navajo child does matter. Specifically, under the Indian Child Welfare Act, tribal courts have exclusive jurisdiction over child custody proceedings involving Indian children living on tribal lands. However, the definition of child custody proceedings under this law does not include an award of custody to one of the parties in a divorce proceeding or a custody dispute between unmarried parents. The Indian Child Welfare Act generally applies where someone who is not a parent is seeking custody of an Indian child, such as by adoption or foster care placement, or in dependency proceedings where the child would become a ward of the state. Under Arizona state law, jurisdiction over a child custody matter is generally based on the child's home state, which is the state or tribal jurisdiction where the child lived with a parent or person acting as a parent for at least 6 months in a row, immediately before the petition is filed, or where the child lived since birth if the child is less than 6 months old. So, As a general guideline, if your child is an enrolled member or eligible for enrollment in the Navajo Nation and living on tribal lands, you should file for custody in tribal court. Also consider home state jurisdiction under Arizona law. If you want a Navajo child custody order to be enforced in state court later, it would be advisable to wait until the child has been living on Navajo tribal lands for at least 6 months in a row before filing your petition there. Marriages occurring on the Navajo Nation may need to be validated. The Navajo Office of Vital Records issues marriage licenses and keeps marriage records. If you are married at a traditional Navajo ceremony, for example, and you obtain a marriage license, you do not need to validate your marriage. However, licenses are not required in order to have a valid marriage under Navajo law. All marriages within the Navajo territorial jurisdiction, where the parties are recognized as man and wife in their community, may be validated and recognized as valid marriages. Proving that a marriage exists may be helpful in certain contexts. For example, if you want to establish paternity or to file for divorce. Let's talk about grounds for divorce in Navajo Nation. You may have heard that Arizona is a, quote, no-fault divorce state. This means that the petition does not have to list specific grounds for divorce, but simply allege that the marriage is irretrievably broken. Under Navajo Nation law, there are numerous grounds for divorce specified. For example, adultery, abandonment, or expulsion lasting 6 months or more, habitual use of alcohol or narcotics, voluntary separation of the spouses for 1 year or more, or other grounds. One of the grounds for divorce is the inability to live together in agreement and harmony, which is very broad and consequently easier to prove. Next, let's talk about paternity. Under Navajo law, a man is presumed to be a child's father in a number of situations. 1, if he was married to the mother when the child was conceived or born. 2, if he attempted to marry the mother, even if the marriage was not valid, when the child was conceived or born. 3, if his name is on the birth certificate or other legal form, and this has not been challenged. 4, if he married the mother after the birth and agreed either to have his name on the birth certificate or to support the child. Or 5, if he welcomed the child into his home and openly held the child out as his own. Paternity must be established before permanent support or visitation is awarded. This is important, so let's say it again. Paternity must be established before permanent support or visitation is awarded. Lastly, let's talk about child custody in the Navajo Nation. In child custody proceedings, including divorces, a Navajo court must provide for the custody and proper care of the child and must act in the best interests of the child. To this end, the court has the discretion to award joint custody to both parents or to award sole custody to one parent. The court may also limit visitation by the non-custodial parent if visitation would endanger the child's physical, mental, moral, or emotional health. The court may consider many factors in determining custody, so-called best interest factors. The primary court case, Lente v. Nota, 1982, lists 34 factors, but I'll just mention a few of these. Some of these factors are fairly obvious, such as the actual living situation of the child, childcare arrangements, prior agreements regarding custody, the child's relationship with siblings, dates of separation from the child, criminal history of the parties, a party's frequent absences from the home, any acts of cruelty, neglect, or non-support, school history, the physical and mental condition of the child, and the child's age and desires. Other factors may be more unique to tribal court, such as encouragement of Navajo cultural upbringing, Navajo custom and tradition, the child's tribal enrollment situation and tribal benefits, race and culture of the parties, and the religion of the parties and religious training of the child. A child's relationship to extended family is also a primary consideration in order for the court to award custody based upon Navajo traditional law. One thing that is not a best interest factor is a parent's gender. There is no presumption in a child custody dispute that a young child should be in the care of the mother. Finally, in order to modify a child custody order, there must be a substantial change in circumstances, and the child's best interests must be promoted by the change. That's important, so let's say it one more time. In order to modify a child custody order, there must be a substantial change in circumstances, and the child's best interests must be promoted by the change. There are two options for establishing child support. One is to file a petition with the Navajo Nation Family Court. This is commonly combined with a petition for divorce or for child custody. Another option is to utilize Navajo Nation Child Support Services and the Office of Hearings and Appeals. The Navajo Nation Child Support Enforcement Act creates an administrative process to assist a party to establish a child's parentage, establish or modify child support, and enforce child support obligations. Information and application forms may be obtained from Child Support Services. The website is listed here. In this process, the Office of Hearings and Appeals holds a hearing and determines the amount of child support. The Navajo Nation Child Support Guidelines establishes a scale of minimum child support contributions. It uses the income shares model, which is based on the idea that the child should receive the same proportion of parent income that he or she would receive if the parents lived together in an intact household. In awarding child support, the court or the Office of Hearings and Appeals will consider a party's ability to pay. It may deviate from the guidelines if it finds that there would be substantial hardship to a parent. For example, if the amount would be more than 40% of a party's gross income, or that it would be inappropriate or unjust, and that deviation from the amount specified by the guidelines would be in the child's best interest. The Office of Hearings and Appeals lacks the authority to modify child support orders issued by the court. It may only modify its own child support orders. These are the basic procedural steps for filing a petition to initiate a court case. Contact the court clerk to get the most up-to-date information. For example, if you want to file by mail instead of in person, or if you would like a list of licensed process servers. When you file your petition, you will have to pay a filing fee, which ranges from $10 to $35 depending on the type of case. Check the rules of court online for a list of fees or ask the court clerk. The clerk will provide a summons at the time your petition is filed. You need to deliver a copy of both the petition and the summons to the other party. This is called serving the other party. You should do this right away. However, you must complete service within 6 months after the petition is filed. The other party must file a response within 30 days after being served with the petition and summons. The court will know that the other party was served and the date they were served when a certificate of service is filed. Request a certificate of service from the court clerk or from your legal service provider. You will typically file the certificate of service with an affidavit, which is a sworn statement describing the time and manner of service, whether in person or by alternative means, such as by certified mail. In order to serve the other party, you will first need to attempt personal service, which means that a police officer, a private process server, or a special appointee of the court will deliver the petition and summons to the individual, or to a person at their residence who is at least 16 years old, or if the other party is a minor, to their parent or guardian. Alternative service by certified mail is available if the whereabouts of the party are known, but personal service cannot be made. Finally, If personal service and certified mail have both been tried and were unsuccessful, the court may authorize service by publication in a newspaper where the person resides or was last known to reside. Here are some actual questions received by law librarians in Arizona. 1. My marriage license is from a tribal court and filed with the tribal court. Can I file for divorce in state court? The answer is, it depends. You can obtain a divorce in Arizona even when you were married in a different state or tribal jurisdiction, so long as at least one of the couple meets the 90-day Arizona residency requirement. The answer is, it depends. You can obtain a divorce in Arizona even when you were married in a different state or tribal jurisdiction, so long as at least one of the couple meets the 90-day Arizona residency requirement. If the divorce involves child custody, generally the children should have lived in Arizona, but not on tribal lands, for at least 6 months before you file for divorce. In the case of Navajo Nation, if the children are enrolled or eligible for enrollment in the tribe and they live on the reservation, the tribal court must determine custody, not a state court. 2. Is a traditional tribal marriage recognized by the state of Arizona? The answer is, it depends. If the marriage was valid under tribal law, it will be valid in Arizona, so long as the marriage is not prohibited under state law. For example, a marriage between siblings. A traditional Navajo marriage ceremony is specifically recognized under Navajo law. However, if you do not have a marriage license issued by the Navajo Office of Vital Records, you may need to obtain a validation of marriage order from a Navajo Nation court. 3. Is a tribal court divorce recognized by the state of Arizona? Can I enforce tribal court orders through the state court, such as orders for child support, parenting time, etc.? The answer is not automatically. A divorce decree needs to be domesticated by filing an affidavit of filing of foreign judgment in state court. The term foreign simply means the decree is from a different jurisdiction than Arizona. There is a similar process for registering an out-of-state child custody order or child support order. Some state courts provide self-help packets for domesticating a foreign family court order. Check with the court clerk in the county where you wish to file. In some cases, a state court may refuse to enforce a divorce decree from a tribal court. For example, if it determines the tribal court lacked jurisdiction or that a party did not have proper notice of the proceedings. However, tribal court orders involving child support or custody of Indian children will be given full faith and credit pursuant to the Indian Child Welfare Act and the Child Support Enforcement Act, respectively. Here are some more actual questions received by law librarians in Arizona. 1. How do I ask for the child support in state court after getting divorced in tribal court? For example, if the tribal court finds it does not have jurisdiction to issue a child support order. The answer is, you can file a petition to establish child support in state court, or you can apply to the Arizona Department of Economic Security Child Support Services to file for child support on your behalf. If there is already an Arizona court order about the child, you should file in the county where that order was issued. Otherwise, you should file in the county where the child lives. You should consult with an attorney if you wish to file in a different county. Arizona state courts often provide self-help packets for establishing or modifying child support. Check with the court clerk in the county where you wish to file. 2. If my child lives on tribal lands, can I file for custody in state court? The answer is, it depends. If your children are enrolled members of a tribe or eligible for enrollment and living on tribal lands, you should file for custody in tribal court. In general, you should file for custody in your child's home state, which under Arizona law is the state or tribal jurisdiction in which the child lived with a parent or a person acting as a parent for at least 6 months in a row immediately before the child custody case was filed, or if the child is less than 6 months old, the state where the child lived from birth. Here are some scenarios to consider when deciding where to file your family court case. Note the assumptions for these scenarios. 1, all parties reside in Arizona, either on or off the Navajo Nation. 2, at least one of the spouses or parents is enrolled or eligible for enrollment in Navajo Nation. 3, any children are enrolled or eligible for enrollment in Navajo Nation. This discussion is informational only and is not legal advice. You should consult with an attorney for legal advice relating to your particular facts and circumstances. Scenario number 1. The spouse seeking divorce does not reside on Navajo Nation. In this scenario, the petition will likely need to be filed in state court because the petitioner, the one seeking divorce, does not meet the 90-day residency requirement for filing in Navajo Nation court. If the other spouse lives on the Navajo Nation and agrees to the divorce, the other spouse may file a petition for divorce in tribal court. Scenario number 2. The spouse seeking divorce resides on Navajo Nation, and the other spouse and the marital home are outside the Navajo Nation. In this scenario, if the marital home and other marital property are in Arizona and not on tribal lands, then the divorce decree's division of property will need to be enforced in Arizona. A tribal court decree will not automatically be enforceable in Arizona. It must first be, quote unquote, domesticated by filing an affidavit of filing of foreign judgment in the Arizona state court. To avoid this step, the petitioner may want to file for divorce in Arizona and obtain a divorce decree from the state court. Note that an Arizona state court may not have jurisdiction over Navajo children living on the reservation. Scenario number 3. In a divorce with children, one spouse resides on Navajo Nation with the children. In general, you should file for custody in your child's home state, which under Arizona law is the state or tribal jurisdiction in which the child lived with a parent or a person acting as a parent for at least 6 months in a row immediately before the petition is filed, or if the child is less than 6 months old, the state where the child lived from birth. Under Navajo law, the Navajo Nation courts can exercise jurisdiction over Navajo children wherever they reside. In this case, the spouse that lives on Navajo Nation with the children should file for divorce or for custody and child support orders in tribal court so that the tribal court may determine custody. Scenario number 4. In a divorce with children, one spouse resides outside Navajo Nation with the children. Under Navajo law, the Navajo Nation courts can exercise jurisdiction over Navajo children wherever they reside. However, in general, you should file for custody in your child's home state, which again, under Arizona law, is the state or tribal jurisdiction in which the child lived with a parent or a person acting as a parent for at least 6 months before the petition is filed. In this case, one of the spouses lives in Arizona with the children, so either spouse can file for divorce or for custody and support orders in Arizona state court. Here are some more scenarios to consider when deciding where to file your family court case. Please again note the same assumptions. Scenario number 5, an action to establish or modify child support against a parent who resides on Navajo Nation. In this scenario, you can file a petition to establish or modify child support in Navajo Nation Family Court. You will first need to establish paternity. For information and forms, check with the court clerk at the judicial district where you wish to file. You may also establish a child support obligation through an administrative process before the Navajo Office of Hearings and Appeals. Contact Navajo Nation Child Support Services for more information and application forms. Scenario number 6, an action to establish or modify child support against a parent who resides outside Navajo Nation. In this scenario, you can file a petition to establish or modify child support in state court. You will first need to establish paternity. For information and forms, check with the court clerk in the county where you wish to file. You may also apply to the Arizona Department of Economic Security's Child Support Services to file for child support on your behalf. If there is already an Arizona court order about the child, file in the county where that order was issued. Otherwise, you should file in the county where the child lives. Consult with an attorney if you wish to file in a different county. For instance, if the child has moved to a different county within the state or has moved out of the state. Scenario number 7, an action by a parent to establish permanent custody order for a child residing on Navajo Nation. In this scenario, you can file a petition to establish child custody in Navajo Nation Family Court. You will first need to establish paternity. For information and forms, check with the court clerk at the Navajo Judicial District where you wish to file. Here are some more scenarios to consider when deciding where to file your family court case. The assumptions 1 through 3 are the same as for the prior 2 slides. Scenario number 8, an action by a parent to establish permanent custody for a child residing outside Navajo Nation. In this scenario, you can file a petition to establish child custody in state court. You will first need to establish paternity. For information and forms, check with the court clerk in the county where you wish to file. Scenario number 9, an action for emergency custody for a child temporarily located outside Navajo Nation, where circumstances include domestic abuse. In this scenario, you could file in state court seeking an order for emergency temporary custody of the child. For more information and forms, check with the court clerk in the county where you wish to file. The Federal Indian Child Welfare Act permits a state court to order emergency placement when the Indian child is not physically present on the reservation, for so long as is necessary to prevent imminent physical harm to the child. Similarly, Arizona state law permits courts to exercise emergency jurisdiction over a non-resident child who is present in the state if necessary to protect the child or a sibling or parent from mistreatment or abuse. Given the legal complexities in a situation like this, it is best to consult an attorney. Scenario number 10, an action by a non-parent to establish custody over a Navajo child residing on Navajo Nation. In this scenario, the petition should be filed in tribal court, applying both the general rule of home state jurisdiction and applying federal law, which is the Indian Child Welfare Act in this case. Here, a non-parent is seeking custody of an Indian child residing on the reservation. Therefore, the tribal courts have exclusive jurisdiction over this child custody proceeding. Scenario number 11, an action by a non-parent, possibly a member of the extended family of the child, to establish custody over a Navajo child residing outside the Navajo Nation. In this scenario, you should definitely seek the advice of an attorney. The applicability of the Indian Child Welfare Act to custody cases involving extended family members, for example, where a grandmother seeks custody of a grandchild, is not settled law in Arizona. However, cases from other jurisdictions have found that the Indian Child Welfare Act does apply to extended family members seeking custody. Thank you for joining this presentation. Contact information for the judicial districts of the Navajo Nation and for DNA People's Legal Services is provided below.